Yes.
My phone name case is not listed for many days. It may come on second.
Next week. Next week. Next week.
Next week. May Lordship. Why not next week on?
Rejected. Second, not possible. Next week. Next week. It would be next week.
My lord, this matter may come up for admission, my lord. It's matter relates to removal from
No,
service.
there is now a system.
My lord, earlier my lord made an application, but it didn't.
No, last 1 month, some system is now in operation. There is a register now where you can enter. Try it. If it doesn't work out, then come back. There is a system now, new system.
Lordship, my lord, I was a CRPF personnel. My service was terminated on medical ground. Then there was a combat force I was. Then there are other avenues that should be appointed me. And they have also said that yes, we will consider, but not considered. Very urgent matter. It may kindly be
Please send your junior to the joint register bench. He will have it listed.
May my lord, motion matter, my lord. Filed on my lord 11/4/2025. May I pray for listing day after tomorrow, my lord.
What is the issue?
My lord, regarding appointment, my lord. He got selection, my lord. But because of my lord,
Monday.
Monday.
May please, your lordship.
May I please lordship for listing of the orders, my lord.
Listing of?
Orders regarding my the termination of my APSC candidate, my lord. Out of that.
No, you just heard what I said. Now there is a
Yes,
new
yes,
system.
yes, yes.
If it doesn't work, you come back.
My lord,
No problem.
much obliged.
May it please, your lordship. Lordship, with the consent of the petitioner, I beg to mention items 17 and 18 for the day, lordship. I have already provided a slip, lordship, yesterday.
17 and 18.
I'm for the petitioners.
You take down Mr. D. Upamanu, Learned Standing Counsel appearing for the Health Department of Government of Assam. 6 adjournment in these matters with a prayer to post these cases again after 4 weeks.
Lordship, after a week, lordship. I'm just
It's
seeking.
not possible. You can't have hearing matters after 1 week.
4 weeks.
After 4 weeks. Since the pair is not opposed by Mr. D.K. Bhattacharya, Learned Counsel for the petition, the same stands allowed. Let these matters be listed again for hearing after 4 weeks.
Highly obliged, lordship.
May I please, your lordship? Lordship, I beg to mention a listing for a repression civil matter on 5th of May.
Go to the register. Yes.
Lordship, same prayer, lordship, for listing.
Same direction.
May I please, your lordship? I beg to mention for listing, lordship.
Mention.
Matter for listing, lordship. The matter was filed on.
What matter? Motion.
Motion, lordship.
When did you file it?
24. 25.
What is the matter about?
Lordship, during the code of conduct, appointment was given.
Monday.
Please, your lordship. Lordship, beg to mention for listing of a matter for withdrawal, your lordship, for day after tomorrow. Oblige, your lordship.
May I please, your lordship?
Yes.
Lordship, the petitioner, he is an employee of the PWD department, your lordship, and he had joined in as a master role worker in 1991. However, his job was regularized on 6 October 2005. I have annexed the copy as annexure number 1, your lordship. Then, your lordship, he submitted on the regularization of his job. He submitted his biodata along with age proof and HSLC examination from SEBA. And along with the admit card, which I have annexed as annexure number 2 and 3, your lordship. After that, he was posted under the executive engineer PWD Nalwadi, your lordship. And then he completed and in all his service documents, his date of birth were endorsed as 11/4/1969, which is correct, your lordship. Then, after passing a long duration, he came to know that his date of birth has been wrongly endorsed in PF account fund, your lordship, which I have annexed in as annexure number 7, your lordship. And he was then intimidated by annexure number 9, that is on page number 30, your lordship, that he has been asked to get retired on superannuation on on
Yes.
30 April 2025. That is tomorrow, Your Lordship.
Mm.
So, I'm challenging this, Your Lordship, Annexure number 9. As in his all documents, including his service book, Your Lordship, his date of birth has been correctly recorded. I got this afterwards, so I'm placing it for the reference of the devotion.
So this memo is of 2nd January 2025,
Yes, Your Lordship.
and you are coming now.
No, I made two representations before the concerned authority, Your Lordship. I was assured that my case will be considered. And then when the representation is pending, nothing has done, no answer has been given to me, then I knocked the door of this esteemed court, Your Lordship.
So what can be done now?
Lordship, my case completely differs from the case which Your Lordship, on the last occasion, the Secretary and Commissioner Home Department and others versus R. Kiruba Karan. My case completely differs. In that also, the question was of date of birth, but in his case, Your Lordship, in his service book, the date was not correctly endorsed, but in my service book, the date is correctly endorsed. But then due to their negligence, this happened, Your Lordship. I'm being asked to retire. I've been asked to get retired on tomorrow, Your Lordship. So can I plead for stay for the timing, Your Lordship? As
That's
my-
not possible. We will just post it for motion. Just see if the date of retirement coincides with the age recorded in the service book. That's all. Just
I'm
find
staying
out.
for a very short date, Your Lordship. Kindly, I'll take the notice and I'll
No,
step.
if you succeed, then we'll see. Not right now, nothing is possible. You have come very late. So it can't
But
be
then,
helped.
Your Lordship,
Yes, heard, Miss. Yes,
speed us, Your Lordship.
yes. We'll have it for motion next week.
Next week. Yes,
Yeah,
sir.
he has to get some time to get the
Can
instruction.
it be fixed by a date, Your Lordship?
Yes,
Yes.
we'll fix a date. Heard Miss P. Das, Naik Counsel appearing for the petitioner, the statements made in the petition. According to the petitioner, the departmental authorities have asked the petitioner to go on retirement with effect from 30/4/2025. Although this said date is not in consonance with the age of the writ petitioner entered in the service book. Having regard to the nature of grievance expressed in the writ petition, this matter is directed to be posted again for motion on next week date, Didier, 8/5/2024-25, so as to enable Mr. R. Dhar Leonard. He is from which department? PWD.
PWD, madam.
Leonard Standing Council, PWD Assam, to obtain preliminary instruction and appraise this court as regards the correctness of the allegation made by the petitioner. 2 extra copies of the.
Yes, yes, Lordship, I will. By date, Your Lordship.
Yes,
May fix by a date.
8/5.
Deeply. okay.
8/5, you're okay?
Yes.
Just find out and give us a copy of it. You can take it back.
Yes.
Take it back.
My lord, I am appearing in item number 226. And there are two others matters. I prepare one of our colleague appears, my lord. এখন
Where is the departmental council?
কোন আছে ডিপার্টমেন্ট কাউন্সিল? মানস জ্যোতি দেখা।
Yes.
Now, if your lordship should kindly come to
No, but
the contract.
Informing me is coming. David.
yes,
Yes, sir.
yes, what is the matter?
My lord, first come to that contract, my lord, page number 21. And relevant page is page 23. We were appointed on contract basis and we were terminated without following the due procedure prescribed by law.
Yes,
The employer reserves the right to terminate the contractual agreement at any point of time if it is found that the services rendered by the contractual employee is not satisfactory, or if it is found that any declaration of information furnished by him, her proves to be false or willfully suppressed, or if there is any breach of any terms and conditions of his terms of contractual engagement, or if the contractual employee is found to be involved in any act that may become embarrassing for the employer in this regard, shall be final and binding on the contractual employee and shall not be subject to challenge. So this is a particular clause which is contained in the agreement which was executed by the petitioner and the department. Now, in this case, a show cause notice was issued on Milord 15/11/22 at page 26.
yes,
In pursuance of the office order dated 25/7/22, I, Sri Ranjit Goswami, ADC, to this commissionerate, has submitted an inquiry report in connection with alleged anomalies and involvement in various irregularities, such as violation of guidelines of PMAGY and the 14th Finance Commission on Borsola GP under Lahoriga Development Block, Morigaon. On perusal of the report, it has come to the notice of the undersigned that while we are serving as Gaon Panchayat coordinator, Lahoriga Development Block, you have done deviation in case of PMAYZ houses, geotagging of the same beneficiaries house in different multiple locations in various stages of level inspections which indicate malafide intentions. In view of the above, you are hereby asked to submit your explanation along with all relevant documents, if any, as to why you shall not be terminated as per terms and conditions laid down in the contractual agreement, which amounts to gross indiscipline as well as gross negligence of duty and misconduct on your part and is unbecoming of the employee in contractual service under the department. So, my lord, mere perusal of the show cause notice itself reflects that because of some misconduct, this show cause notice has been issued. Therefore, it has got nothing to do with clause 13 of the agreement. They themselves profess that I am guilty of misconduct, therefore this show cause notice. Now, I submitted my reply at page 27. In this regard, I, Manoj Jyoti Deka, humbly inform you that I have been serving as GPC since so-and-so from 2015 in Borolimari GP and on 1/10/21 to till date in Borsola GP, and have been serving in 2 Gaon Panchayat to the best interest of the office as well as to the superior officers, and have no complaint from any corner. That, sir, when I joined Borsola GP, I am not aware about area of GP village. So I have taken help from member of GP secretary for official work, particularly PMAYZ houses inspection and geotagging purpose. Sir, we have done the PMAYG registration and geotagging as per the office order that so-and-so given by the GP secretary, Borsola, Sri so-and-so, depending on target of PMAYZ, which was 1800 approximately. I have informed you that I have not done any geotagging against beneficiaries where a complaint arises as was done by other GP official. Sir, I have done geotagging of PMAYZ beneficiaries with the help and presence of ward member of that particular ward for identity of beneficiary. Sir, I have done, sir, if I have done any mistake knowingly or unknowingly for inspection and geotagging, sir, please excuse me for mistake which was not intended. Anyway, my lord, his stand was that whatever I have done, I was done in presence of the GP officials, and therefore beyond that, he has got nothing to say. Now at page 28 is the impugn order. In pursuance of the office order number dated 25/7/22, the inquiry officer has submitted the inquiry report whereby Manoj Jyoti Deka of so-and-so under so-and-so was found involved in various irregularities such as violation of guidelines of PMAYZ and 14 Finance Commission. Whereas show cause notice has been served by the commissioner's letter dated so-and-so. On the basis of the inquiry report submitted by inquiry officer against Manoj Jyoti Deka, a Gaon Panchayat coordinator under Lahorigarh Development Block, Morigaon Jilla Parishad. Whereas reply to the show cause notice is submitted on 15/11/22 by Sri Deka, which is found not satisfactory. In view of the above, and in pursuance of clause 9 of the contract agreement, Sri Manoj Jyoti Deka, Gaon Panchayat of GPC Borsola under Lahorigarh Development Block, is hereby terminated with immediate effect. In lieu of notice, in view of the circumstances, 1 month's salary is to be paid to the concerned employee. So apparently, my lord, there was a show cause notice. I submitted a reply, and there was an inquiry. In that inquiry, I was never associated with. And apparently, they derive power from clause 9 of the contract agreement. Now, clause 9 of the contract agreement, the one which I executed is something else. Now, in the affidavit filed by the department, they have annexed a model contract. If your lordship will kindly have the affidavit filed by the department, it is at page 49. And that particular clause is in paragraph 9. This is a model contract agreement which I never executed because the one they have annexed is a blank. So it does not bear the signature of anybody. It's a model contract which contains a termination clause. At page 51 is clause 9. Now, my lord, in the factual background, the legal issue which arises for consideration is whether services, number one, services of contractual employee can be terminated in the manner it has been done. Number two, if stricto sensu, Article 311(2) may not apply, but whether the actions has to be consistent with the principles of natural justice. And number three, whether a contractual employee or a temporary employee, whether they're entitled to protection of Article 311 or analogous provision. So in my humble submission, my lord, these are the three issues which arises for consideration. My lord, I'll be relying on few judgments. I'll just hand over the copies. Janu. এই judgment দুটা নাই আনিব দি আছো। I'm handing over few judgments on the three propositions which লাগিব এটা কপি এটা লৈ আছো নেকি এখন আহিছে নেকি 2002 1 SCC 520 বাকি কিটা ঠিক আছে আছে। My lord, first lordships will kindly come to
Yes.
this AIR 1963 SC 531 paragraph 4. Please come to para 4 of the judgment. What is one I have to answer? Huh? Oh. The judgment. Citation to him. তোমাকে আমার দিয়া নিয়ে যেতেও নি দিয়া আমার আছে নাকি নাই নাই মই
What is the name of the party?
yes Madan Gopal.
Yes.
Now, my lord, para 4, it's a very long paragraph. Here, appellant was a temporary employee. If your lordship should kindly come to the next page, the third sentence from the top. The appellant was given an opportunity. Has your lordship got it?
Yes.
Yes. The appellant was given an opportunity to make his defense, and it appears that witnesses in support of the charge and in defense were examined before the settlement officer. The settlement officer reported that on evidence he was satisfied that appellant had received 150 years illegal gratification and that the appellant did not enjoy good reputation and was a person of doubtful integrity. So in the facts of this case, my lord, the opportunity was given. It is now well settled that protection of Article 11(2) of the Constitution applies as much to a temporary public servant as to a permanent public servant. By virtue of Article 311 of the Constitution, the appellant was not liable to be dismissed or removed from service until he had been given reasonable opportunity against the action proposed to be taken in regard to him. The appellant was given no such opportunity, and Article 311 of the Constitution was therefore not complied with. So, my lord, whether you are a contractual employee, whether you are a temporary government employee, if you want to do away with the service, then you must follow the minimum procedural requirements, safeguards. If you don't do, then you do it at your own peril. Then next, my lord will kindly come to 1979 1 SCC 477. 1979 1 SCC 477.
Yes.
Manager Government Press versus D.B. Beliappa.
Yes. Which paragraph?
Yes, please come to para 18, my lord. Mr. Virappa's at page 483. Mr. Virappa's first contention is that Article 14 and 16(1) of the Constitution have no application whatever to a case of a temporary employee whose services is terminated in accordance with the terms and conditions of his service, because the tenure or duration of the employment of such an employee is extremely precarious, being dependent upon the pleasure and discretion of the employer state. In our opinion, no such generalization can be made. The protection of Article 14 and 16(1) will be available even to a temporary government servant, and if he has been arbitrarily discriminated against and singled out for harsh treatment in preference to his junior similarly circumscribed. It is true that competent authority has a discretion under the conditions of service governing the employee concerned to terminate the latter's employment without notice. But such a discretion has to be exercised in accordance with reason and fair play and not capriciously. Bereft of irrationality and fairness, discretion degenerates into arbitrariness, which is the very antithesis of the rule of law on which our democratic polity is founded. Arbitrary invocation of enforcement of service condition terminating the service of a temporary employee may itself constitute denial of equal protection and offend equality clause in Article 14 and 16.1. Article 16.1 guarantees equality of opportunity for all citizens in matter relating to employment or appointment and to any office under the state. Moreover, according to the principles underlying Section 16 of the General Clauses Act, the expression appointment used in Article 61 will include termination or removal from service also. Now, my lord, in this context, para 19 is also important because when we speak of equality, it doesn't mean it is initial appointment, it includes everything. It is now well settled that the expression matters relating to employment used in Article 16.1 is not confined to initial matters prior to the act of employment, but comprehends all matters in relation to government, both prior and subsequent to the employment, which are incidental to the employment and form part of the terms and conditions of such employment, such as provisions to salary, increment, leave, gratuity, pension, age of superannuation, pension, and even termination of employment. It is further well settled that Article 14, 15.1 and 16.1 form part of the same constitutional code of guarantee and supplement each other. Then eventually, my lord, please come to para 25. Another facet of Virappa's contention is that the respondent had voluntarily entered into a contract of service on the terms of employment offered to him. One of the terms of that contract embodied in the letter of his appointment in this date, that his service was purely temporary and was liable to be terminated at will and pleasure of the appointing authority without reason and without notice. Having willingly accepted the employment on the terms offered to him, the respondent cannot complain against the impute action taken in accordance with those mutually agreed terms. The argument is wholly misconceived. It is borrowed from the archaic common law concept that employment was a matter between master and servant only. In the first place, this rule in its original form, original absolute form, is not applicable to the government servant. Secondly, even with regard to private appointment, much of it has passed into fossils of time. This rule held the field at a time when the master and servant were taken more literally than they are now, and when, as in the early Roman law, the right of the servants, like right of any other member of the household, were not his own, but those of his better families. The overtones of this ancient doctrine and are discernible in Anglo-American jurisprudence of 18th century and first part of the 20th century, which rationalize employer's right, absolute right to discharge the employee. Such a philosophy, as pointed out by K.K. Matthew J. by his treatise Democracy, Equality, Freedom of the Employer's Dominion over Employee, may have been in tune with the rustic simplistic of the bygone days. But that philosophy is incompatible with these days of large impersonal corporate employers. To bring it in tune with the vastly changed and changing socioeconomic condition and modes of the there is much of his old, antiquated, and unjust doctrine has been eroded by judicial decisions and legislation, particularly in the application to persons in public employment to whom constitutional protection of Article 14, 16, and 311 is available. Argument is therefore up. So, my lord, way back in 79, these propositions of law were clearly called out, where a right of the employer of a fair treatment was recognized, be it in the matter of appointment, be it in matters of any other aspects of condition of service, including termination, where, my lord, the employee's right of a fair hearing was recognized. Now, my lord, the next citation is 2022 6 SCC 346. If your lordship would kindly come to paragraph 14, which is the operative, final conclusion of the Honorable Supreme Court.
Yes.
It could, at page 350, it could thus be seen that though the communication of the said university dated 12/8/14 states that the appellant's contractual period has expired, in the facts of the present case, it would reveal that his services were discontinued on account of allegation made against him by Dean of the said university. Since even according to the said university, though employment was contractual, but the employee was entitled to get all benefits of a regular employee, we find that in the facts of the present case, the appellant's service could not have been terminated without following the principles of natural justice. We therefore find that the present appeal deserves to be allowed on this short ground. So, my lord, in a very recent judgment, this Honorable Supreme Court took the view that merely because a person is in contractual employment, that does not mean that when it comes to, dealing with his right following from his condition of service, a different view can be taken in respect of permanent government employee and in respect of contractual employee. Now, my lord, now another Supreme Court judgment, my lord, I've given a copy to reported noise action UP State Road Transport Corporation versus Brijesh Kumar. In this case also, my lord, show cause notice was not issued. Please come to para 19 at page 8. These services of the respondent have been determined solely on the ground of misconduct as alleged, but without holding any regular inquiry or affording any opportunity of hearing him. The termination order has been passed on the basis of some report which probably was not even supplied to the respondent. Perimeter facts as in the case. No show cause notice appears to have been given to the issue to the respondent. Of course, in my case, it is given. Therefore, the order of termination of his services, even if on contractual basis, has been passed on account of alleged misconduct without following the principles of natural justice. The termination order is apparently stigmatic in nature, which could not have been passed without following the principles of nature and justice. So, my lord, mere service of notice is not enough. A proceeding may not be as strictly as in 311(2), but minimum procedural safeguards has to be followed. Now, in this case, in our present case, apparently there was an inquiry. I was not even part of that inquiry. So, where is the scope of relying on that inquiry report? Logovati to dekhalo niki? Dekhalo. 14 dekhalo. Mangilal dekhalo.
Yes.
Now, my lord, I'll rely upon two judgments of our High Court by two coordinate bench, my lord. Imran to Arvata Saddam. এখন দিয়ক না। Now, this is, my lord, WPC number 104 of 22, Mohammed Saddam Hussain versus State of Assam. And it was disposed of on 16/11/22. Now, if your lordship would kindly come to para 13 at page 7. Service law jurisprudence do recognize the concept of placing an employee under suspension if he is arrested and in custody in any criminal matter, wherein also the seriousness of the allegation have its own relevance and further action under the law may also be permissible. Accordingly, we interfere with the order dated 7/21 of the Commissioner, same department, by which services of the petitioner was terminated, but grant complete liberty to the respondents in PNRD department to act against the petitioner in appropriate manner under the law as may be advised. As the proceedings initiated by the show cause notice dated 28/21 has not been brought to its logical end, and the authorities have deviated by resorting to the impugn order of termination dated 7/9/21, the respondents are also given liberty to proceed further pursuant to the show cause notice dated 28/21 by bringing the same to its logical end. And in doing so, petitioner may also be given an opportunity of hearing and be allowed to produce any relevant materials he may desire to produce. Having noticed the seriousness of the allegation against the petitioner, we further provide that as a consequence of interfering with the order of termination dated 7/9/21, it would be deemed that petitioner would be under suspension. So absolutely similar circumstance, my lord, as show cause notice was given, then a reply was filed, then the interim order was passed. This honorable court says no. Since you have issued a show cause notice, you conduct an inquiry and bring the case to its logical end. There's one more judgment, my lord, of a coordinate bench. Imran. Imran, এটু দিয়া আছে নেকি 4266 of 23 civil rule, Imran Hussain. এক সেকেন্ড এরকম দেখা আছে আইটেম নাম্বার কিমান পেজ My lord, in item number 1, this particular judgment which I intend to rely is already annexed. Page start home. At page 82, my lord, is another judgment by coordinate bench.
Yes.
Please come to para 19. In the light of the allegation on which the service of the petition,
Yes.
para 19 of the judgment. In the light of the allegation on which service of the petitioner has been terminated, the Honorable Supreme Court of India in case of Purushottam Lal Dhingra reported in has already held that even for terminating a temporary employee, the principle of Article 311 was required to be complied with. Similar view of the Supreme Court of India has also been expressed in so and so, wherein it is reiterated that termination of service of a temporary government servant without any stigma would amount to punishment which may not be made without any inquiry. However, it is specifically held that even as a temporary government servant, delinquent is entitled to protection under Article 311 of the Constitution, where termination involves stigma or amounts to punishment. Therefore, the two cases cited by the learned counsel for the respondents do not help to espouse the cases of the respondents, and this case is bound to be similarly situated with the facts of Ali Ahmed Borgnia. Accordingly, this court is inclined to hold that by merely providing inquiry report to the petitioner at the stage of issuing show cause notice is not sufficient compliance of the principles of nature and justice. And as the service of the petitioner sought to be terminated on the ground of irregularity and misappropriation of government fund, petitioner is found to be entitled to be given an opportunity of being heard, as the nature of stigma attached in the impugn order dated 13/7/23, apart from being stigmatic, is likely to cause serious prejudice to the petitioner in his future prospects and employment opportunity. Accordingly, the court is inclined to hold that termination order dated so and so, but same department, thereby terminating the service of the petitioner, is not sustainable in the eyes of law, and the same is liable to be set aside and quashed. Respondents are directed to reinstate the petitioner in service forthwith within a period of 15 days from the date of receipt of the certified copy of the order. Upon reinstatement, it would be open to the respondent authorities to proceed against the petitioner in accordance with law by serving proper show cause notice indicating specific charges brought against the petitioner. In doing so, it would be open to the respondent authorities to place the petitioner under suspension pending trial or conclusion of the departmental proceeding if so advised. However, upon suspension, petitioner would be entitled to subsistence allowance. Respondent authorities are directed to strictly comply with the requirement of the provisions of rules of 64 as well as principles of natural justice. On completion of such inquiry, it would be open to the competent authority to pass appropriate orders as may be deemed necessary. So, my lord, like a government, substantive government employee, my lord, a temporary government servant is also entitled to all the procedural safeguards. And your lordship judgment is also there, which we have annexed in the writ petition itself. We have annexed.
Item 1, which page is the order of termination? Item 1.
What about 65? Itu কোনটো আছে এইটোৱে না আমি যদি সুৰজিত বৰ্মন তোৰ পাৰ্ট অফ টিমটো কি এইটো এটা বেলেগ Stigma judgment to down. What do you think?
And which page is the contract agreement in item 1? Sorry? This contract is for how many days? We have, Mr. Datta, what is the duration of the
My
contract?
lord, the paragraph 3, my lord, last paragraph. Maximum 364 days.
Subsequently extended. Is there any order of extension? No. Yes.
Yes. My lord, your lordship's order is also there in the writ petition, page number 30. Item number 2. If your lordships would kindly come to page 38.
Yes.
Last but one paragraph at page 38. Situated thus, this court is of the unhesitant opinion that order of termination dated 30/10/21 is unsustainable in their law. Therefore, the same is set aside. Respondents are directed to reinstate the petitioner back in service within 10 days from the date of receipt of the copy of the order. After reinstatement of the petitioner, it would be open for the respondent to proceed against him in accordance with law by serving proper show cause notice indicating specific charges brought against the petitioner. In doing so, it would be open to the department to do the same,
But in
order.
this case, no show cause was served.
Yes, which case,
In
Milord?
this case,
Yes, yes. Yes. By following, look, question is merely because if a show cause notice is issued and the reply is filed, that is not enough. Milord. The purport of all the preponderance of view in my humble submission is that you have to hold an inquiry. End of the day, you are taking note of some misconduct. That is why, my lord, in the context of stigma, Supreme Court says, if somebody is removed, a probationer is removed because of unsuitability, it's okay. Then it will not attach any stigma. But the moment you say, I was found irregular in my duties, that I was guilty of wrongdoing, etc., then that means you have taken.
that there is no difficulty in
Yes.
accepting.
Yes.
But
Well,
enquiry is to be held in accordance with which rule?
in one of the judgment, 1964 rules, Assam Services Discipline Appeal rules, or at least a procedural, my lord, which will conform to the requirement of natural justice. For example, my lord, there will be a so-called notice, then there will be a, my lord, reply, then an inquiry officer will be appointed. There may not be rules, but he will follow the basic rules of natural justice. If they are relying on a document, then they will prove that document. If I want to cross-examine the witness, I should be given an opportunity. This is at end of the day, you are taking note of some misconduct. If it is merely unsuitability, that so and so is not found to be suitable for further retention, that is a different game altogether. That's why, my lord, this in the context of this stigma, my lord, there is a judgment 2002 1 SCC 520. Pale? 2002 1 SCC 520. Para 29. Please come to page number 529.
Yes.
Now please come to placitum Z. Although strictly speaking, the stigma is implicit in the termination, a simple termination is not stigmatic. A termination order which explicitly states what is implicit in every order of termination of a provisional appointment is also not stigma. The decisions cited by the parties and noted by us earlier also do not hold so. Now, this is very important. In order to amount to a stigma, the order must be in a language which imputes something over and above the mere unsuitability of the job for the job. Supposing I am not efficient, I am not my
You are reading from which paragraph of this?
para 29 minute at page 529. I can read the whole parameter.
Yes, yes.
Before considering the facts of the case before us, one further seemingly intractable area relating to first stage needs to be cleared. What language in a termination order would amount to a stigma? Generally speaking, when a probationer's appointment is terminated, it means that probationer is unfit for the job, whether by reason of misconduct or inaptitude, whatever the language used in the termination order may be. Although strictly speaking, stigma is implicit in the termination, a simple termination is not stigmatic. A termination order which explicitly states what is implicit in every order of termination of a provisioner's appointment is also not stigma. The decision cited by the parties and noticed by earlier also do not hold so. In order to amount to a stigma, the order must be in a language which imputes something over and above mere unsuitability for the job. The moment, my lord, there is something more than mere unsuitability, then it will comprehend what we generally understood as stigma. My lord, there is another judgment of your lordships. Copy extra. Yes. WPC 4061 of 23, a judgment by your lordships, Partho Protein Soikia, by following the judgment at page 30 of the writ petition. Kuntu. Milord, I'm sorry, I left out one very important paragraph. If your lordship would kindly come to page 30. Page 38, Milord, of the writ petition. Page 38, internal page 9, the first subpara. It is no doubt correct that in case of a contractual engagement, the terms and conditions of contract would be governed by service conditions of the employee. In the present case, the contract agreement signed by the petitioner does not have a clause permitting termination of a contract at any point of time if the service rendered by the contractual staff was not found to be satisfactory. However, what is to be noted herein that bare perusal of the impugn order of termination demonstrates on the face of the record that the same was issued on the basis of finding of inquiry proceeding conducted behind the back of the petitioner, wherein it had been projected that petitioner was guilty of misconduct. Therefore, the order of termination of service of the petitioner, dated 30/10/21, is not only based on allegation of misconduct, but is also stigmatic on the face of the record. In other words, impugn order of termination dated 30/10/21 was founded on allegation of misconduct. However, petitioner was not given an opportunity of being heard in the matter. Therefore, it is a case where respondents have acted in violation of the principles of natural justice. The order of termination from service issued to the petitioner has the trappings of an order of dismissal, removal from service. Therefore, such an order could not have been issued without giving the employer an opportunity of being heard, even if the same pertains to temporary or contractual. This is for the simple reason that such action, besides causing serious prejudice to the interest of the employees, would also have a bearing on the prospect of his future employment. And in the Parthoprotim Psychias case, my lord, relying on the same proposition, lordship has interfered and allowed the writ petition. That is copy to 9 here. Parthoprotim to delay. Here, my lord, at page 16, Lordships has quoted that paragraph in Ali Ahmed Barbuya's case. Then, my lord, at paragraph 9, Lordship refers to another court of bench judgment in Soilendra Bora and other cases. Then, eventually, at paragraph 13, for the reasons stated herein above, all the writ petitions succeeds and are hereby allowed. Impugn order of terminations involved in the respective writ petitions are set aside. Respondents are directed to reinstate all the writ petitioners back in service within 3 weeks. So therefore, my lord, there are other cases also, but more or less on the same line. So I will not like to multiply the authorities, my lord. The stand taken in the affidavit is they have a model contract, and model contract, they could not produce any contract agreement which was signed by the employer and the employee. Therefore, this is neither here nor there. But in my humble submission, it's an open and shut case where clearly, my lord, even if we don't say Article 10 and 11 in stricto sensu, the principle of natural justice or the procedural safeguards emanating from that principle was not extended. Therefore, the impugn orders are bad in law and it same needs to be interfered with. Of course, in many of the cases, your lordships, while interfering, has given them liberty to proceed against the petitioner in accordance with law by placing the petitioner under suspension. That principle can also be adopted. This is my humble submission.
My lord, for my reply, my lord, these cases are serious in nature, my lord. I accommodate lordship, may accommodate some time, my lord, so that I can prepare and reply my seniors' submissions, my lord. And also I have to go through the judgment say referred, my lord, because that was not served on us, me, my lord. Some reasonable time, my lord. Any date may be fixed, my lord.
At 2 o'clock?
My lord, because I have to go to the judgments and I have to also rely some judgment to counter that, my lord.
No,
Thursday
in
maybe,
this, all
After
right,
tomorrow.
that is not the issue. Some enquiry has been held, is it?
Yes,
But this enquiry, where is the enquiry report?
that was served on on the petitioners, my lord. The
No,
inquiry.
where is it?
My lord, for that, my lord, lordship may grant, day after tomorrow may be fixed, my lord.
In
Who was the
affidavit,
enquiry?
it is not stated that inquiry report was given to us.
My lord, in the impugn order itself, it was there, my lord.
That is why I'm asking.
Yes, my
Now you issue a show cause notice. Let us look at it objectively. We are on legal principles.
lord.
The first of all, these are all contractual employees. They were appointed for a fixed term. There is nothing to show that their contract period was extended, but they
Yes.
have been allowed to continue.
Yes, without extension.
Now, the department has the option not to renew the contract or to say that the contract is expired. So yours, for that ground, your services come to an end.
Yes.
Instead of doing so, you are complicating matters yourself.
Yes.
You have first come up with allegations in a show cause notice. These allegations appear to be prima facie allegations of misconduct.
Yes.
If it is an allegation of misconduct, you will have to conduct proper inquiry. Question doesn't arise. And that inquiry must be after giving him an opportunity of being heard.
My lord.
So none of the cases you have met that
My
requirement.
lord, for
Just a
only
minute,
that
just a
point, my
minute.
lord. Yes.
So unless you can show that you have held inquiry, you have first of all, you have to serve a memorandum of charge, which you have not done.
Yes, my lord. Admittedly.
And then you have to appoint an inquiry officer. The parties will have to be given opportunities to prove their respective versions. There is an inquiry report. Then this is a major penalty you have inducted,
Yes.
termination from service.
Yes.
So whether Rule 9 of the Rule of 1964 is strictly applicable or not,
Yes.
you have to follow the principle. In principle, you have to follow. So all the orders will go.
Yes, my lord.
Yes.
If
Whether it goes today or on Thursday, it will go.
lordship, yes. If I will.
But your option is, listen to this.
Yes, my lord.
If you withdraw all the orders of termination, then it will be up to you to clarify what is the status of the contract. Whether the contract has been extended.
My lord,
In
for
some
that
case, you
reason-
may extend, in some case, you may not. That liberty you will have. But if you invite a judgment from the court, then you know where it is heading.
Yes, my lord.
Thursday,
Thursday, my lord. Yes,
discuss with your client and come back.
my lord. Thursday.
Only if you withdraw, you will have the liberty. Otherwise, the liberty will be very, very restricted.
My lord.
And of course, the law which has already been declared consistently will have to be followed.
Yes,
This-
yes.
Some cases you have served show cause notice, but that is not enough. You have held inquiry, you say there is an inquiry report, you have not involved them in the inquiry proceeding.
And most importantly, my lord, there are so many judgments, they have not preferred appeal in any of the cases. Yet they are continuing with the same
My lord,
modus.
Parthapratim Saike already appeal filed, my lord.
Hmm?
Parthapratim Saike case, my lord, already appeal is in file.
But there is no stay.
My lord, not listed yet, my lord.
Hmm?
Already
There
it is filed.
There are other orders against which you have preferred appeal which have been dismissed.
No, my lord.
All right, that is another matter. You get a stay order, no problem.
Yes.
But what I'm saying is, subject to what you may argue, it appears that this matter has only one course. Unless you withdraw the order of termination, then your right to take action under the contract will revive.
Yes, sir.
Otherwise,
My lord, I have found some judgments actually, my lord, from this honorable court also, my lord. Being the officer of the court, my lord, it's my duty to place before those
that is
judgments.
all right, but have you understood the query?
Yes,
of
yes,
the-
I understood what lordship is saying, man.
If the order of termination has to be set aside by a judicial order, then the matter will go in one direction.
My lord.
But if you withdraw, then your right under the contract will then come.
Well.
Which is whether you want to extend the contract
Yes.
further or you want to say
I
that the
understand
contract.
what Lordship is saying.
In that case, the matter is different. No
My lord.
principles of natural justice.
My lord, my lord.
इनके लिखो heard Mr. Kane. Thursday.
Thursday.
Mr. Kane Chaudhary, Learned Senior Counsel, assisted by Mr. R.M. Dekar and Mr. K. Mira, Learned Counsel, appearing for the writ petitioners in this batch of writ petitions. Arguments on behalf of the petitioner is heard on the request of Mr. S. Datta, Learned Standing Counsel for the PNRD Department, Assam. These matters are directed to be listed again on day after tomorrow, date to be due 1/5/2000 as fixed item for admission hearing.
Highly obliged.
My lord, can I take little liberty in respect of item number 13 some other day, item 13? I can do it on Thursday also. Actually, yesterday I was very late, could not go through it. Or some other day, my lord. Item 13, it was a slightly longish matter.
Who's
I
for
mean,
the-
from the other side,
Highly obliged.
Thursday, we have already fixed other matters.
some other day.
When do you want it?
My lord, it can be on 20 May, my lord, 28 May, no?
Okay. You are appearing in this
Oh,
case.
For the petitioner.
sorry, 22nd, my lord, 22nd of May. 22nd.
22nd May. On the request of Mr. Kane Chaudhary, Learned Senior Counsel, appearing for the SPOS number 4, you are appearing for this number. Made with the consent of the other side. Hearing of these matters stand adjourned to 22/5.
Yes, my lord.
2025. Mr. Sahu, Learned Counsel for the company petitioner is present.
Waiting for respondent number 4.
Ms. N. Rahman, Learned Counsel, has appeared on behalf of respondent number 4. So you are for whom, Mr. Chaudhary?
I am for the 1, 2, 3.
Acha, Mr. Chaudhary is assisted by Mr. Khandelia for respondent numbers 1, 2, and 3. Yes.
Deep.
Just keep it in the first file. Hmm.
May please, Your Lordship.
Yes.
Pursuant to the order of this
Yes.
honorable court, my lord.
May I just draw my lord's attention on 7/1/2025 order,
Just a minute. Take your seat. Just a minute. 7/1.
2025.
Yes. What do you want to show, Mr. Kosi?
My lord, I have placed that instruction, my lord. After the order from this honorable court, my lord, the inquiry report was submitted. They have submitted their reply also, my lord. In terms of proviso to Rule 10, my lord, the views of the APSC has been sought for, my lord. The entire record has been sent to the APSC, my lord. And these are the, my lord, officers, my lord, who were selected by the APSC, my lord.
That will proceed. Now today we'll decide on whether the suspension is valid or not,
But
because you have
it's-
taken a lot of time.
I understand, my lord, because the allegation is of such a
Maybe,
nature. my lord.
but you
And
should
in
have
fact, my
come.
lord, it is reviewed again time to time, my lord. This is the
That,
latest,
that will answer. If he has a case, we'll interfere, otherwise we'll dismiss it.
because the last
You
review,
took time on the ground that the inquiry is completed, we'll take a decision. That also went up more than
no,
4
my
months.
lord, no, the first the inquiry was completed in the first round of litigation.
Hmm.
Thereafter, my lord, when the inquiry report was submitted to him, my lord, he made an application before the authorities that he has not been heard, he has not been given the opportunity to heard, and therefore, my lord, page
No,
61.
is there any statutory requirement to take the opinion of the APSC for
For a
taking?
proviso to Rule 10, my lord, sir, even if government thinks it necessary, my lord, the commission views are to be taken, my lord. Because these are the
Tomorrow
offices, my lord, which are,
Send it to United Nations. Another 6 years will go. We can't see, the question here is whether his prolonged suspension is justified or not. Today we'll decide that. Let him argue, you argue, we'll decide.
No.
You do whatever you want to do with your. Earlier, the time was granted because you said you are taking a decision expeditious. But that has now not happened. So let it happen.
no, my lord, the
You may
earlier,
have your recourses, but
No.
we will not grant you time for that.
my lord, the earlier, my lord, what I prayed for was that the inquiry report was about to be completed. We were supposed to give him the inquiry report, my lord.
Hmm.
The lordship gave a direction to give us the inquiry report. That has been given. He took time to file his reply. He took extended
So,
time.
all right, now
Now,
you go ahead with the matter in your own way. We have nothing to say. The issue in this case is whether his suspension, prolonged suspension is justified or not. We'll examine it. If we find it is justified, we'll dismiss the writ petition. If it is not, then we'll allow the writ petition. It may take you 6 months, 8 months, 2 weeks, 5 weeks. We don't know.
in fact, I have an instruction, my lord, we can complete it better 3 weeks, my lord. Because we have sought the
No,
APSC views, my
we
lord.
can't keep doing this. We have
Because
given
the
you.
government has already expressed
Hmm.
that to impose a punishment under Rule 7, my lord. And for that, my lord, Rule 10 provides, my lord, the proviso to Rule 10 is, my lord, where it's necessary. In case of,
Unless he agrees, not possible. Not possible. You got your time, you could not use it, matter ends there.
because as if
Are
I
you agreeable for another 3 weeks? But your writ petition may be dismissed also. If that happens, then you are stuck up.
And let it be done, my lord.
Huh?
Let it be done, my lord.
What?
3 weeks, my lord, and fixed date, my lord.
You will pass a final order within 3 weeks.
my lord, I'll inform, my lord. In fact, I have an instruction to ask for 3 weeks time though.
If both of you agree, I am ready to decide the matter today itself. But
No.
which way the decision will go, that I cannot.
I think, my lord, your lordship will give us 3 weeks time, my lord. It would be helpful for him also, petitioner. My lord, the
My lord, all right.
decision will be taken.
My lord, a fixed date may be, my lord, my lord may kindly see the last order also of this honorable court. Last order.
I've seen it.
In fact,
Yes, yes. Therefore, my lord,
as your lordship is
I-
fixing dates, my lord, the matter is moving, my lord.
last date will be at
All right, I heard Mr. T.H. Hazarika, learning counsel for the writ petitioner, also heard Mr. D. Kaushik, learning standing counsel for the school
Department of School
education,
Education.
Department of School Education, Assam, who submits that after receiving the response of the petitioner with regard to the inquiry report, the government has referred the matter to the APSC under Rule 10,
Proviso to Rule 10.
under proviso to Rule 10 of the Assam Service Disciplinary
Disciplinary.
Rules 1964, seeking its opinion. And as soon as the opinion is received, a final order bringing the departmental proceeding to its logical end would be issued. According to Mr. Kaushik, the said process will be completed within 3 weeks from today. Therefore, a prayer has been made to list this matter again after 3 weeks. The prayer made by Mr. Kaushik has not been opposed by Mr. Hazarika, learned counsel for the petitioner. In view of the above, and on the request of learned counsel for the respondent, this writ petition is directed to be listed again on 16th of May,
16th of
16th of May 2000.
preferably within 3 weeks.
My lord, that is the difficulty, my lord.
But otherwise, it would be an undertaking.
With an agreement that if no final decision is taken in the matter by that time, the writ petition will be taken up for disposal on merit
Very well.
Deeply
Great
appreciated.
comment.
on the next date fixed.
My lord.
Yes, who's for the respondent?
My lord, Senior Counsel Mr. P.K. Tiwari is appearing on behalf of respondent, but he's on legs in another court. But in the meantime, if my learned senior can start.
I can start or I can work for him also.
Let him come, it will be better.
That will be better.
Because then he may not be aware of some of the arguments. We'll
Madam.
pass it over for the time being. Yes.
Madam.
My pleasure.
Yes.
This case related to the appointment of some of the home guard who were acting as a PSO in the different district of Silang during the emergency period, my lord, 2008 to 2012, my lord. In the year 2014, they have been taken to for weaponry training of 4 months in the district of Sonitpur under the respondent trade, my lord, battalion. And after receiving the weaponry training, they have been posted as PSO in the Silang district, my lord. But at the time of appointment, they were given assurance that if you give if you do your work properly, then you will be considered for the appointment of Assam security force, my lord, and Assam battalion, etc., my lord. At the time they were appointed, but after some times, on 1/7/2014, they were released. They were released from the PSO and again posted as home guard in their under the control of respective superintendent of police. The petitioners belong to the Kamrup district, my lord, and they were working as now the home guards, my lord. But as per assurance given by the government that they will be considered for the appointment of the Assam security force, this was not done, my lord, up till now. So the respondent, they have filed and submitted one advertisement. The issue, I'm giving the copy, I have sitting in the records, my lord. Earlier I have given in the record. As far
This one.
it will have, that, my lord, it is published on 13/12/2017. Last that we have submitted the copy. This copy was furnished to us by the respondent, my lord.
This copy.
Yes, madam. So that is in continuation of this office advertisement that is 13/12/2017 for recruitment of release for the filing of the 145 post of the constable in Assam Industrial Security Force from SPOS, Special Police Officer, those who work in Dhuburi and BTAD during 2012, 12 ethnic problems, and the SPO who were deported in the district of Bongaigaon Irang, Baksha, North Kasar Hills for National Highway and the railways line security along the military in the pay scale of so and so, the pay scale of, and the others admissible admissible allowances. It is for general information. So, as per this advertisement, my lord, those who were working in the 2012, my lord. But my petitioner, they were appointed in 2014 after taking weaponry training. So their contention is that as the advertisement was already issued and the process was already done, so this case is infractious, my lord. But my contention is that my petitioner, they were working in 2014, but here it is for 2012, my lord. So if they can prove that it is the case, this advertisement will cover all the cases of 2014 also, then my case is infractious, my lord, no matter. But according to my,
Yeah, just 1 minute, just 1 minute. So, you are saying that according to them, your clients are covered by this
yes,
notice.
covered by this advertisement.
Is that correct?
Yes, Lordship.
Then is there a statement on affidavit to the effect?
No, Lordship, so far in my instruction, Lordship, it is stated that however, as per the government letter dated so and so, dated 18/01/2018, the SPOs whose were deployed in the various district of Assam, all the SPOs, Lordship, for national highways, railways line security during the military, during the military machinery in NC Hills were also allowed to apply for the same, which was conveyed to all the concerned by this office notification dated 24/1/2018, Lordship. Others are also, they may also apply.
Let me see.
Yes.
Then you file a short affidavit.
Lordship.
Let him file a short affidavit, we'll close the matter. Had
One
Mr. K.
affidavit has been filed very common, that's not about thing, but regarding that, about they have.
No, it has to be filed by government,
Lordship.
by Secretary of the Home Department.
Lordship.
Had Mr. K. Sharma, learned counsel appearing to the writ petitioner in both these writ petitions. Also heard Mr. J. K. Goswami, learned additional senior government advocate Assam, appearing for the state, who submits that as per the instruction received by him, all SPOs, including the writ petitioners who were deployed in various districts of Assam for national highways, railway line security, etc., during the militancy in NC Hills, including those who were deployed in the BTAD areas during the ethnic problems in the districts of Bongaigaon, Chirang, Baksa, and NC Hills. Would be covered by the advertisement notice dated 13/12/2017. Full stop. Mr. Sharma submits that if that be so, the grievance of its clients would stand redressed. However, for the purpose of disposal of the writ petition based on such submission of the learned additional senior government advocate, an affidavit to that effect would be required. As such, on the request of Mr. Goswami, learned counsel, additional senior government advocate Assam, these matters are directed to be listed again on 26th of May 2025 as fixed item. An affidavit from the Secretary to the Home Department of Government of Assam to the above effect be brought on record in the meantime by serving advance copy upon the petitioner's counsel, facilitating disposal of the writ petition on the next date fixed.
I had dealt with this matter, my lord. Last
Sorry?
time, my lord, I had suggested me some suggestion, my lord, whether the DP is perverse, my lord. The order passed by the appeal authority and the authority, my lord, is perverse or not, whether non-passing of the inquiry report
Hmm.
is fatal, my lord. So this point, my lord, I prepare, my lord.
You got the judgments.
Yes, my lord.
Yes. What are the facts?
Now, my lord, in pursuance of the FI,
You just take
yes.
sit for 2 minutes. He was dismissed from service
Yes, ma'am.
in the year 2014.
Yes, madam. After appeal has been preferred, madam, that is also not rejected, madam. In the appeal, madam, the appeal authority observed, madam, it's a violation of 311(2) of the Constitution of India, madam. On the ground that, madam, the inquiry report was not furnished to the petition, madam.
Yes. So what are the grounds on which you are challenging?
Now, madam, my first ground is that, madam, the whole proceeding, madam, the natural justice of the petitioner has been violated, madam. The first part, the presenting officer was not appointed, madam. The inquiry officer, madam, himself, madam, examined the witnesses, madam. He has re-examined the defense witness also. He has examined the, madam, defense witness and cross-examined him also, madam. I mean,
Then number two,
number two, madam, the inquiry report was not furnished, madam. So in the inquiry report, there is a perversity. Madam. They have gone beyond the charges, my lord. And third one is that, madam, no defense assistant was appointed, madam. The inquiry officer did not inquire from me, madam, to whether defense witness assistant is required or not, my lord.
no presenting officer appointed.
Yes, my lord. And as per Supreme Court, madam, the Bogotam case, madam, the inquiry officer, at least, madam, inquiry from the, madam, the delinquent or petitioner, madam, whether he is engaged any, madam, defense assistant or not. That was also not done, madam. There is husband of the High Court, of our High Court also, madam.
All right. Let us see the allegation.
Yes, madam. First, madam, kindly see page number 22. That is the FI, madam, from where the whole case proceeding has been started, madam. I think.
Yes.
The FIR is filed one Madam Meena Begum, my lord.
Hmm.
On date of occurrence of 27/7/2010, my lord, at about 8:15 PM, my lord, at Lotagota Bosisto area, my lord.
Hmm.
Where one person, my lord, was succumbed to his injury, my lord, and no, one lady was sustained injury, my lord. May I read, my lord?
Hmm.
Our here, the petitioner as well as the Rina Khatun, my lord, were arrested, my lord, and the
What happened in Basista PS case?
his trial is going on, my lord. Next day is 23/6/2025, my lord, for evidence, my lord. And I'll show, my lord, it is a case of no evidence, my lord. In fact, my the injured witness, my lord, he himself said that the petitioner did not shoot at us, my lord.
Hmm.
Now the respondent are trying to shift the burden, my lord, upon me, my lord. Because in the statement before the proceeding, my lord,
Now, you have a situation here which is not a very happy situation.
yes, my lord.
Petitioner is facing trial
Yes, ma'am.
for committing offense under 302.
And there also the three vital witnesses were not appeared, my lord.
That is all right, but
But there is chance of acquittal, my lord.
although these proceedings are to go independently,
Yes,
but
yes, ma'am.
the fact remains that the courts will have it in the mind.
Yes, ma'am.
In case of acquittal, your arguments gets far more stronger, and the
Yes,
court will also
yes,
have a
ma'am. Yes,
that then what is the misconduct?
yes, ma'am.
But before the acquittal happens, now the prosecution witnesses are being examined.
Yes, madam. As per me, sir, all the evidence of PW has been finished, madam. Only part of PW2 has not yet finished, madam. So in a retail, I have took a plea, madam. Since the both the cases, madam, are based on same sets of allegation, madam. So it should be kept in evidence for time being, madam. But it was not, it was rejected, madam.
Which should be kept in evidence.
The bail proceeding, madam. After madam issuance of the show cause notice, madam.
So you want to now proceed with this? So you have to take a decision because this is a very tricky area.
Yes, madam.
Same set,
Yes,
civil, criminal. Supposing it is allowed,
Yes, ma'am.
well and good. Still, whether there can be an order of reinstatement is another matter.
Yes, ma'am.
Supposing it is dismissed and you are acquitted,
Then again, my lord.
then what will you do? Have you thought about those things?
Yes, ma'am. But can
So
it be,
these are really
yes, yes, sir.
critical
I also
questions.
thought,
Huh?
but can it be after my vacation or summer vacation? It is better.
So it's all right. You want to argue today also, we are okay. If you want to argue after summer vacation, but you have to be very clear about these implications.
Yes, obviously, my lord.
After summer vacation.
Yes, my lord. Summer.
Yes, Mr. Goswami,
Proceed.
you are appearing for whom?
Lordship, the respondents. Lordship,
All the respondents. You have to call him then. So you give us a progress report also.
Lordship,
By the next date.
regarding the position of the criminal trial, Lordship.
No, because you see, if there is no evidence, then his right also has to be protected. Can't be that 15 years have gone already.
Lordship. Then
In the evidence also, they admitted that the main culprit, the police could not arrest, which was actually involved in this.
So that is all right, but we can't comment on the
Yes, madam.
criminal.
As per our
charge.
records, madam.
But the trial should be expedited.
Yes, madam.
Lordship.
No, you are saying yes, but what steps have you taken?
I will write to the prosecutor, Lordship.
But can it be observed, the trial should be expeditiously.
Heard Mr. S. Bothakur, learned counsel appearing for the writ petitioner. Also heard Mr. J.K. Goswami, learned additional senior government advocate Assam appearing for the all the
All the
respondents.
respondents.
For the respondents and stuff. It has been submitted at the bar that the writ petitioner is facing trial in Bosisto case number 360/2010, registered under section 447/326/307/34 of the IPC, read with section 27, bracket numerical 1, bracket close, again bracket numerical 2, bracket close, again bracket numerical 3, bracket close of the Arms Act. Since the outcome of the criminal trial would have a serious bearing in the present proceeding, hence this court is of the view that a status report as regards the progress made in the criminal case is required to be called for before proceeding further with the matter. The learned counsel for both the sides have also agreed to such a recourse. In view of the above, Mr. J.K. Goswami, learned additional senior government advocate Assam, to produce a status report with regard to the stage of the trial conducted in connection with Vasishta PS case number 360 of the
It is now, madam, the session case number 266 only 15 minutes.
pertaining to
The 266 only 15, the session case trial is, madam.
Kamrup Metro.
Yes, madam. Addition, this
Pertaining
is
to sessions case number
266 only 15, pending in the court of addition, district and session judge number 1, Kamrup Metro.
pending in the court of addition district and session case, Kamrup Metro. We got the number. The learned additional senior government also advocate to also appraise this court as to whether any steps have been taken on behalf of the state to expedite the trial in connection with the aforesaid case. By facilitating the above, let this matter be listed again in the month, in the second week of July 2025. So some written note of submission was required to be placed, is it?
Yes, I shall place it tomorrow. Because I had not completed my argument on that day. And that is why, my lord, if your lordship, then I can prepare it, I can give it tomorrow. Or if you want to, your lordship wants to.
The idea was first to go through the written note and then
Actually, my lord, our difficulty is unless and until I know on what grounds
I will give it tomorrow.
the order is under challenge, it becomes very difficult.
that is your written argument.
It's a, my lord, it's
That is
a,
a-
that's precisely
ground.
because my lord is under the certiorari jurisdiction. They have come under certiorari. It's either perversity or jurisdictional error. Neither of the two have been argued till now. So unless and until they demonstrate that there is perversity in the order of the trial court, or that there is a grave and serious jurisdictional error, I can understand that.
No, that's right. I think there is a confusion. The court did not call for written arguments.
I shall give it
The
tomorrow.
court
Or-
has given a
Notes.
call for a written note on submissions.
All right, tomorrow, my lord.
And my lord, my submission is subject to their submission.
All right, I will-
Right now, I have given my submission. I'll be arguing on certiorari jurisdiction.
No, you want to argue, you argue. No problem.
No problem. It will be better on my part also. It will be convenient on my part also. Because on that table, I have not given all the judgment. I have just one page note. One or two points.
Then day after is not possible. Then it will
Tomorrow.
go-
My lord, day after actually, I haven't parted. So I was in fact in VC only. In the Itanagar bench, there is an election matter. So on first
That
again,
will
my lord,
happen on third week of May. On a
that's better. my
non-miscellaneous-
lord. That's better for
It's a
us.
date. Or you can, lordship can take it
On a non-miscellaneous day, third week of May.
any day.
I'm
your
here.
lordship.
The third week of May, I'm here, my lord. Third week of May, I'm here. Except 19th, except 19th. 19th, there is election petition.
Mr. A. Dasgupta Lanet, Senior Counsel for the writ petitioner, submits that the written note of submission called for by this court is not yet ready. Therefore, he be granted 10 days further time to prepare and submit the same. Mr. P.K. Tiwari, Lanet, Senior Counsel appearing for the respondent, is present and submits that the matter be heard after the written note of submission is circulated. In view of the above and on the request of learned counsel for both the sides, let this writ petition be listed again on 15/5/2025 as a fixed item subject to availability of
Yes,
the bench.
15th is perfect.
In that note, I shall refer the judgment to be laid upon.
Please do. Please refer the judgment. So we can go through the note and then the time taken in the argument will be much less. In
Because
the
on that
meantime-
day, I could not refer all those judgments. 2 or 3 judgments.
So far as the basic principle is concerned regarding 2 capital A vis-a-vis 33 2B, I'm not disputing the proposition that has been argued. Yes, the trial court can very well go into the whole matter. I won't dispute that principle. I'm basically, my lord, I would be confining my argument to the scope of a certiorari jurisdiction, whether there is perversity in the judgment of the trial court and whether there is a jurisdictional error. That's all.
That's right. But whatever, see, what happens is these are a little areas which are a little. So if we have the benefit of a written note of submission.
That is,
becomes-
unless I see there,
Tomorrow itself, I can give it.
lot depends, my lord, as to what argument do they advance. Otherwise,
Tomorrow or day after tomorrow, I will place it.
No, you give it next week, no problem. Give it to her.
with copy to us, so that,
Yes, you can also give your response.
sure,
This is written note on submissions.
very well.
Whatever is your submission.
Then I will anticipate their argument.
Yes, next matter. Third week of July, make it third.
On a small prayer, my lord, the records of the trial court are here. Many of the exhibits we don't have. So, my lord, we may be allowed to inspect the records of the trial court.
No problem.
If need
In
be,
the
my lord, we will
meantime,
take the copy.
learned counsel for both the sides are permitted to inspect the record of the trial court and if necessary, obtain certified copy of the documents by following the due process. That's not, is it?
Yes, my lord. Lordship will find the impugned order at page 76, my lord. Whole facts are, my lord, reflected here, my lord.
Hmm. Page 76 is the order dated 10th February
My
2020.
lord, my lord.
What is this order?
My lord, by which, my lord, as per directions of this honorable court, as well as, my lord, affirmed by the division bench of this honorable court, and as well as the, my lord, honorable Supreme Court, my lord, the petitioner has been reinstated, my lord, in service. And but the period from the date of removal to the date of, my lord, reporting, that period has been treated as, my lord, there is none, my lord.
Just give the facts in a nutshell.
Yes, my lord. My lord, petitioner is a, my lord, constable in the, my lord, CRPF, and my lord, he was, my lord, removed from service, my lord, after, my lord, the departmental, my lord, proceedings, my lord, wherein, my lord, the charge has been framed, my lord, and the inquiry report has been submitted on a, my lord, non-stated charge, my lord. And the petitioner challenged that, my lord, removal order before this honorable court, my lord, and this honorable court, my lord, interfered with and set aside this, my lord, a removal order, wherein, my lord, this honorable court held that the removal order is, my lord, based on the inquiry report, and the findings of the inquiry report is, my lord, on a, my lord, unstated charge, that is, my lord, suicide.
Where is the order passed by the court?
That lordship will find this page 53.
Page 53.
My lord, relevant portions lordship will find page 57, paragraph 16. Paragraph 16, my lord, page 57. May I read, my lord? Following the above discussion, the impugned office order dated 5/3/2009 is found to be unmerited, as the same is based upon the unstated charge of suicide attempt. The evidence on the contrary suggests that the firing of the weapon was accidental rather than a deliberate act. Therefore, the disciplinary authorities cannot treat this matter as a case of major misconduct. For the accidental lapse, any of the other minor punishment barring removal from service as specified in section 11 of the CRPF Act can be reasonably imposed. Thus, the punishment order dated 5/3/2009 is set aside and passed and subject to medical fitness. The constable is ordered to be reinstated in service. The authorities are at liberty to impose any lesser minor punishment for the lapses committed by the delinquent. It is ordered accordingly. Here, lordship will find the findings of this honorable court, my lord, is not that there is no any misconduct, but it was only the lapses and on the part of the petitioners, my lord. And
No, but the court has permitted that punishment can
yes,
be.
that is there, my lord. But my submissions before this honorable court that since there is this honorable court findings this as regards there is no any misconduct on the part of the, my lord, petitioner.
No, major misconduct. Court says major misconduct, not no misconduct. Where is
Major,
the finding that there is no misconduct?
no, major misconduct, my lord, but the findings is only as regards the, my lord, lapses. But so far the lapses, my submission is that so far the lapses is concerned, my lord. That part, my lord, it was the accidental one, my lord. That is the findings, my lord. The evidence on the contrary suggests that the firing of the weapon was accidental rather than a deliberate act.
Mr. Sharma, please be very clear on a few things. There was allegation of misconduct against your client.
Yes, my lord.
Then they conducted inquiry.
My lord.
And found that misconduct was established.
My lord.
And the major penalty of removal from service was imposed upon your client.
My.
So that was a major penalty.
Yes, my.
So you challenged it and the learned single judge has held that the bullet went off on an accidental situation. Although there could be lapses, but these are not major misconduct. Because major misconduct term may not be there in the rule book. What the learned judge meant is that was not a misconduct inviting a major penalty. But it could be treated as a misconduct inviting a minor penalty. So what was set aside is only the order of penalty, not the finding of misconduct.
No.
Right? And liberty was granted to the respondents to impose any
Lesser.
other lesser penalty. Authorities are at liberty to impose any lesser minor punishment for lapses committed by the delinquent.
Right.
Now, what was the penalty imposed after this?
That Lordship will find page 76. Is 11 portion, Lordship will find page 78, paragraph 10. Number one is reinstated in service. Number two, intervening period from 5/3/2009 to 17/11/2019. Total so and so will be treated as dies non, and on the basis of the mowbray, he will not be entitled to back ways for the said period. And as per verdict of this dated so and so of the Honorable Court, accidental error committed by so and so, he is hereby awarded punishment of stoppage of 1 increment for 1 year without cumulative effect.
So for pension, your pension will not be affected.
My lord, that is not, my lord, clear also in the, my lord.
It is clear.
It is clear.
And for the period you have not worked, they said no work, no pay. Because your misconduct has not been interfered with.
Not interfered by my submission is that since it is a lapse, my lord, and it is a accidental one, my lord. So authority, my lord, ought to have considered, my lord, that part, my lord.
When punishment is also not challenged.
Punishment I have not.
Lesser punishment which has
Punishment,
been
my lord, I
imposed.
have not challenged.
So-
This rate petitions, my lord. My limited, my lord, prayer that part, my lord. And this,
Yeah, but you have to show me where is the law supporting your argument.
yes, my lord, that part, my lord,
The law is rather against you, no
Yes.
work, no pay.
yes.
Then
But only one judgment, my lord, I am relying in that respect, my lord.
see, it is a different thing. If the action was without jurisdiction,
Yes.
then the matter was different. But the court's view is that only the penalty should be lesser.
Yes.
Than removal of service.
My only submission is that since it was, my lord, only the accidental lapse on the part of the petitioners, my lord. So it was not
Then
deliberate
you have
what,
to
my lord.
challenge the order of penalty. That's what he is pointing it out.
That, my lord, penalty part I have not challenged.
Then without challenging the penalty, how the court can interfere with this?
Only, my lord, backways part, my lord. Only, my lord, this backways part, my lord.
That cannot be considered, Mr. Sharma.
The last occasions, my lord, my friend, my lord, relied on one judgment, my lord, wherein, my lord, the Honorable High Court of Tripura, my lord,
So they have treated this 10 years as on duty for the purpose of pension.
only for the purpose of pension.
But you can't get paid your salary for that period. Sorry, that's not permissible. And here you have not even challenged the order of penalty. Do you want a judgment of dismissal?
This repetition, my lord. As your lord says, my lord, but my lord, only one part.
No, you are understanding, no? There is no hazy area here. It's very clean. The
Yes.
writ petition will be dismissed.
That's.
Do you want that order?
Hmm?
Don't be emotional. It's a question of our client's
Yes, my lord.
interest. No, you want some time to think. I'll give you. There's no problem. Don't hurry into a decision. But you are against a wall. You have not challenged the order of penalty.
I have not.
10 years you have not worked. The principle is no work, no pay. The misconduct still remains. Only the penalty has been brought down. So this is also part of the penalty that the period will be dashed on. Correct. But they have been liberal with your client by allowing that period for computing his pension. So notionally the period will be counted. But now if you fail to succeed in the writ petition, then it may have other ramifications.
Lordship may take it, some other day, my lord, I will take instructions, my lord, and I will, any date, my lord.
When do you want it?
Next week, my lord, next week, not then next.
On the prayer of Mr. R. Sharma, learned counsel for the petitioner made with the consent of Mr. H. Gupta, learned CC appearing for the state. Hearing of this matter stands adjourned for a week so as to enable Mr. Sharma to obtain updated instruction from his client. Whether the petitioner would like to press this petition at this point of time. Prayer allowed, let the matter be listed accordingly. You have a discussion with your client,
My
and
lord,
see
my
what he
lord.
says. You have not even paid for back wages.
The question I have paid.
No, before the,
Yes, that.
then you have not paid, the learned judge has not granted you. The order appears to be perfectly in sync with the single judge's order. Now you have not challenged it, but you want the court to go beyond that order. Difficult. All right.
Lordship, here in this case, Lordship, it is directed that to produce the original record, Lordship. The record is not not received, Lordship. I'll fix the matter after 1 week, Lordship. I will produce.
My lord,
What is the matter about?
my lord, he is a jail warder, my lord, the petitioner.
Sorry?
Petitioner
Jail
was
warden.
a jail warder.
Jail warden.
There are several jail warders in a particular day, my lord.
Hmm.
At least there are 5 persons. Without ascertaining the fact of the time of the escape, the one person has been penalized, the petitioner.
Departmental proceeding, Lordship.
Next Tuesday is a fixed item.
Yes.
Heard Dr. P.K. Goswami, learned counsel for the petitioner on the prayer of Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the state. This writ petition is directed to be listed again on 8/5/6/7/5, is it? Next Tuesday. Next Tuesday, 6/5. 6/5/2025 as a fixed item for hearing so as to enable him to produce the record. It is made clear that if the records are not made available on the next date fixed, his court would be compelled to draw adverse presumption against the
23
state.
matters. 23 matters. 2023 matter.
Maybe, but you get it.
Lordship,
You already got 3 weeks.
Lordship, Lordship.
This is the last item. Yes.
This application, by this application,
No.
challenge.
In this case, actually, I was directed to produce the original record, my lord. Just the original record I am holding, my lord. Disciplinary, original record of the disciplinary proceeding, my lord. Some actually on difficult, my lord. Let him start, my lord, but for giving me reply, my lord, I may be given some time, my lord, because I will have to have a discussion with my client, my lord. Let
That
him
means
start,
the
my lord.
matter will have to be made part heard.
My lord. No. Next,
Now I'm not sure how the bench will be available. So
we know about the bench is a bit because I'm not hurry, my lord.
all right,
Let him start, my lord.
yes.
The petitioner herein has challenged the order by which the
Order is at page 73.
page 70.
Yes.
Yes, my lord.
Yes.
The salary, you know,
Please.
HQ in Article 1 was working as DGM in Palipara, subdivision Fulbari under an NESCP project from November 16 to February 18. During this posting at Fulbury, he was looking after the construction of the ward of the Fulbury station. Timothy Nijamani Gogoi, wife of SK Bukon, received 1,000 from something from her bank account from Chicho Soikia, a labor contractor engaged by Mekon, executing the Fulbury station towards hiring charges of art exhibitors owned by her. Sri Pukon thus resorted to business with the working contractor under his control and misused his official position for personal gain. Thus, by the above, Sri Pukon failed to maintain absolute integrity, acted in a matter which is unbecoming of a public servant, misused his official position, acted in a manner prejudicial to the interest of the company, and violated company's Pukon violated rules iman of the power grid rules. Then number 2. Pukon, while posted at Fulbury, deliberately concealed the facts of acquiring 2 numbers of JCBs by his wife, which worth rupees 25 lakhs something, and purchased on 3/2/15 and rupees 27 lakhs something purchased on 8/3/17 while submitting his annual property returns in ending 15 and 17 respectively. Further, Sri Pukon did not give any intimation as per Power Grid CDA rules while acquiring both the JCBs. Thus, by becoming a public servant, acted in a manner prejudicial to the interests of the company, violated company's rules, and failed to report transactions concerning movable property. Pukon violated such rules. Then 3. Pukon, while posted at Fulbury, possessed 2 and 3 RA bills dated Iman without taking measurement of the art work in with respect to the site leveling work of Iman of KV substation, and undue benefit has been extended to the contractor. Thus, Pukon has abused his official position to pass an order, under favor to contractor by the way of paying the undue amount of rupees 23 lakhs 24,000, etc. Thus, by the above, Sri Pukon failed to maintain absolute integrity, acted in a manner which is unbecoming of public government, acted in a manner prejudicial to the interests of the company, and violated company's rules. Sri Pukon violated rules iman. Then 4. Pukon, while posted at Fulbury, possessed 2 and 3 second and third RA bills for the same on the same day, that is on 25/9/5 month, for 37 lakhs and 16 lakhs respectively, to authorize the bill for payment within his power of delegation of his power grid delegation of power. Thus, Sri Pukon resorted to splitting of the payment of the 2 bills intentionally so that the bills could be approved by him without sending it bill to the higher authority. Thus, by the above act, Pukon failed to maintain absolute integrity, acted in a manner which is unbecoming of a public servant, and violated company's rules. Whereas Sri Pukon acknowledged the receipt of the memorandum of charges submitted in Iman, then after discussing this, Milon, the findings and others is held that now therefore, last page 76, now therefore having considered the total facts and circumstances and documents and records of the gravity of the misconduct, the penalty of compulsory retirement is imposed on the disciplinary authority on Sri Pukon under Iman. The appraisal of evidence and its analysis, as mentioned above, are the considered views that the disciplinary authority and the undersigned has been directed to serve this order in terms of Rule 28 of the Power Grid rules and on behalf of the disciplinary authority. The receipt of the order should be Iman. So, holding that all the charges have been proved by the authority, they compulsory retired the petitioner from service. Against that, Milord,
That happened in the year 2020.
My lord.
This order is of 2020.
My lord.
Where is the order of penalty?
That is there, my lord.
Is it 2/3/2021?
Mm. 29/10/20, my lord.
Which page?
73. It begins.
And what is the normal date of retirement in Power Grid Corporation?
60.
And how old is the petitioner now?
Is 52, 18.
For 4.5 years late, my lord. 4.5 years, my lord.
4.5 years more to go.
More to go.
So he's about 55 years. So if he succeeds, then a reinstatement is possible.
No.
If he succeeds.
Well,
That's true.
Yes.
At the time, in 23, he is 54 million.
All right.
At the
So-
time of
20.
What are the grounds on which you are challenging this order?
I'm challenging this order mainly on the ground that these findings based on the evidence is not sustainable, my lord. Because I will go article wise.
No, sustainable means, are you saying these are perverse?
At some cases, these are not supported by evidence, so it will be perverse.
No, the finding of fact can be interfered only if it is perverse, not otherwise.
Yes, it will be.
And what is the other ground?
And in two cases, they are not based on evidence and
No, Mr. Chaudhary,
Because of-
your first ground is that the inquiry report is vitiated by perversity.
perversity.
What is the other ground? What are the other grounds?
Other grounds are not, my lord, this is not based on the proper appreciation of the position of the.
That's perverse. Yes. That's perversity.
That is the perversity.
Then only ground is perversity. No other ground.
And it is not based on evidence also.
The same thing.
Because they have failed to
No,
consider some.
am I clear about my query?
Yes, no.
I'm saying you are assailing the inquiry report. One of the grounds, as you say, is perverse. Findings
Yes,
are perverse.
findings are perverse.
What are the other grounds, if any? Is there any other ground of challenge?
So that in one case, it will be based on, it is a case of no evidence at all. No.
That is perverse. That is.
That
If
will
it's
be
a
the
case of
meaning.
no evidence. That is the meaning of, that is what is called perverse. So anyway, your only ground is perverse. Okay. So can we see the finding of the inquiry, the inquiry report? Which page is it? Which finding is perverse according to you? Appreciation of evidence, the court cannot go into under Article 226. That law is well settled.
Inquiry report is at page 41, my lord.
Page 41. Yes. It is 41 to 72. Is it?
Yeah.
Page 41 to
72.
all right. So which finding is perverse?
From page 51, Milord, you'll also will find the conclusion and findings.
Yes. Page 51.
Here,
Yes.
it is chart number 1, where by which it is alleged that he has engaged his wife as a contractor in the company's work.
No, is that the charge number 1?
Yes, Milord. Imputations of no, Lordship will find that at page 26.
So
That number articles of charges.
would you like to have a closer look at the records and then argue, or you want to argue today? Your choice.
Yes, Milord.
You,
That is true, Milord.
no, it's okay. It's okay. Would you like to argue today, or you want the matter to be posted on some other day? You can also go through the record
Let it be on some other day, Milord. Then.
because this matter will take half an hour. And if we go in the speed that I want to go, but it will be difficult unless we understand these are matters, you have to have the facts in the fingertips. So up to you. If you want to argue today, then you argue, or I don't want to keep matters part-head. I would like to finish it today itself. My question will be very simple. The only ground on which findings can be looked into is perversity. That's the only ground. Wrong appreciation of evidence, not a ground for the Great Court to look into. So, is that your only ground? If that is your only ground, which finding is perverse? And for that, we have to go through the records. So, have you seen the records? You also will have to have a look at the records. Otherwise, whether a finding is perverse or not, you have to point it out from the record. Are you prepared for that today?
That way, I have not seen the original records. I have seen only the records that is available with me.
All right. So, do you want to inspect the original record? Up to you. If you want, then
I am ready, Madam. Because we are
then it is up to you. You tell the court what you want. You want to argue today, but I'll conclude it today. Already more than half the day is left.
Yes, ma'am.
So if we go into the merits, then we'll finish it off today. And then how will you show perversity without consulting the record?
Evidence parts, they have produced in the affidavit. So from there also I will.
Okay. So there is no need to see the record.
In our affidavit, my lord, we have annexed all the evidence, my lord.
Article 1, I'll go from Article 1, Milord.
Okay.
Instead of going into the Article 1 it is statement of Article 1 at page 26. It reads as H.K. Fukon, general manager, Balipara, was posted at Fulbari NCP February 19. During this posting, he was looking after the construction work of the Fulbari substation and Srimati Nijumani Gogoi, wife of received H.K. Fukon, received Iman through her bank account bearing Iman in the State Bank of 6 Mile from Sujya Soikia, a labor contractor charged engaged by the main contractor at Fulbari substation towards hiring charges of excavator owned by her. Sri Fukon reverted to business with the working contractor under his control and misused his official position. So here, Your Worship will see the charge is that I have engaged myself, I have allowed my wife to be engaged as a contractor in the company and thereby received this amount from the, but the actual fact is, Milord, the
Yes.
the petitioner's wife owns those two excavators and she has a hiring contract with another person. She does not use it, Milord, herself. She has given it on rent to a person who uses it for his work. And I get the monthly rent, whatever is due from them. And in this work also, you'll actually find the evidence is,
Yes.
no, evidence is that on this issue, Milord, the evidence you're also will find at page 174, 75.
Yes. Yes.
He states that I have seen at page 174,
Yes.
I have seen mutual agreement that a demand executed between Nijumani Saikia, Nils Gogoi, wife of Sri H.K. Pukon, and John and Pramod Gogoi, resident of Ward number 3 Iman, Assam, pertaining to excavator, friend Iman. And then again, next page 175, Sirajul Islam, towards middle, I have entered into an agreement that the demand, I came to know that Srimati Gogoi is wife of Iman. I only telephone and talk with him, and during that period, then later your lordship will find question number 4. I know Abhijit Gogoi who is working with Sujo Saikia. And on demand of Abhijit, I had sent the said excavator for work for his requirement. This excavator was earlier used by him for transmission line of the Fulbari site. This vehicle remained with him from Iman to Iman. Vehicle was not given to Abhijit thereafter. So it clearly shows that his wife has not done the contract work. She only hired, she only gave the excavators on, and this person who had the contract, this Sirajul Islam had the contract agreement with the petitioner's wife, who owns the JCB's Milan, and he utilized the JCB's for his work, labor contract. And by that Milan, whatever money was due, she received. So thereby this finding, Milan, that she worked as a contractor under him is belied. Am I clear, Milan?
Yes. So this is the evidence of
Article 1.
PW, 2 and 3.
This is evidence of the Sobin Borgohai. He is what? What is his? His witness DW2. All right. So how his evidence has been dealt with by the inquiry officer?
That way, I don't see any from his deliberations, Milan, that it reads this way at page 51, Milan.
Page 51. Yes.
Yes, 51 of the paper book.
Yes. Yes, please.
It has been established that the total amount of demand was paid to Nizumani Gogoi in her bank account. There is no document on record to show that CEO obtained any permission from the department or the business with the working contractor under his control. Produced evidence of the execution of Sirajul Islam given by the executor, and for a period demand agreement only establishes that the said executor was given on rent to Sirajul Islam. So that way she wants to, the inquiry officer goes against this, Milan.
But what is the perversity in this finding?
Established, and it says further. Thus, they established that during the inquiry, CEO, while working as man, as general manager Fulbari project, was looking after the construction of the Fulbari work, and Nizumani Soikia, his wife, received the money. Only money received was taken as the proof, Milan, of her working. But actually, she didn't work. That was a higher charge she received from the contractor, labor contractor who used the vehicle.
So you are saying that it was a case where the excavators owned by the wife of the petitioner, which was let out on rent, was used,
utilized in the work.
and the money she got is the rent for the excavators. Correct? So what was the rent for the excavators? Where is the rent agreement? Let us see, test this argument. On what rent was the excavator let out by the petitioner's wife? Is there any agreement?
At 175, you also will find at the rent of rupees, at the rental rate of rupees 130,000 per month. At page 175. her agreement with
1,30,000 per month.
yeah,
Page 170,
175.
175. So per excavator was 1,30,000 per month.
My lord. And he states, my lord, this Sirazul says, here, I know a visit who's working with Suchar Saikia towards bottom and demanded, on the demand of a visit, I had sent the said excavator to our work for his, as per his requirement. Was earlier used by him in the transmission work at Pulvar site. In question 4, he stated. So whatever money she received was I have charged only for the vehicles, which was
But
used
she
by the
has received
contractor.
2,37,000.
My lord, my lord.
That 2,37,000 is rental for how many days?
This is a vehicle remained with it from 12/4 to 29/4.
But article says November 2016 to February 2018. I was wondering whether it will be good if you make a note of what are the
Charge.
charges, in which charge, which are the perversities, and then address your argument with the legal authorities. I think that will be better.
I think that will be.
Yes. Which evidence is there, which is not there. Otherwise, going from this page to that page is. What do you say?
That will be easier for your lordship, my lord, to arrive it.
Yes, because otherwise, you will also find it a little confusing. See, the plea of perversity means we have to look into the evidence, findings and then evidence.
That's
So it is
the
better
evidence
to.
will be only clear.
When do you want it?
After a week, my lord.
After?
After 1 week.
Okay. On the request of Mr. D. K. Chandil and his senior counsel, assisted by Ms. S. Roy, M. Roy, and counsel for the petition. Hearing of this matter stands deferred by so as to enable him to prepare a brief note. Mr. Das, N. Das, N.C. Das, Learned Senior Counsel, assisted by Mr. N. Khera. Learned Counsel is present on behalf of the respondent and does not have and submits that the departmental records have been received by him and can be perused by the court. Any firm date you want?
My lord, 30th of May, common day.
30th.
Can come up as a fixed item on 30th of May, my lord. 30.
On the request of Learned Counsel for the respondent, let this petition be listed again for hearing on 30th of May 2025 as a fixed item.
Highly obliged.
Obviously.
It will be better to have a note and these points, then with reference to that, then we can finish it off early. Right?
Get it.
Butter.